Good afternoon, everyone. I, Srushti Waghmare, welcome you all to the last topic of today's session, that is revocation of representation proceedings, where representation is already granted. To guide us through this important topic, we are honored to have with us an esteemed speaker, Advocate Kanetkar sir. Sir has been practicing lawyer for an impressive 43 years, specializing in civil law, cooperative matters, election disputes, 49 years, specializing in civil law, cooperative matters, election disputes, intellectual property rights, revenue cases, arbitration, debt recovery, consumer law, and service matters. Beyond his legal practice, he has made significant contribution to legal education, having served as a part-time professor at ILS Law College, Pune for over 32 years. He is also a chairman of governing body of Indian Law Society. His leadership extends to the Bar Council of Maharashtra and Goa, where he was not only elected as a member but has also served as its chairman. Additionally, he played a crucial role in legal reforms as a member of Maharashtra Government Committee for amending Maharashtra Cooperative Societies Act 1960, following the 97th Constitutional Amendment. Sir has delivered numerous lectures at various universities and actively contributed to the continuous legal education program conducted by Bar Council of Maharashtra and Goa. Sir, we are truly honored to have you with us today and we look forward for your valuable insights. Now I request Dr. Nilima Bhadbade ma'am to felicitate Shrikant Kanetkar sir. Thank you, ma'am. Moving forward, we have already explored the necessity of obtaining representation, the procedure, and its legal effect. However, it is equally important to understand when and how a grant can be revoked. But the question comes is, why does revocation matters? Well, imagine a situation where someone fraudulently claims your inheritance and the court unknowingly grants them the key to your success. It's like someone stealing your Netflix password and locking you out of your own account. Well, don't worry. This is where revocation takes as a safeguard, ensuring that the only rightful beneficiaries manage a deceased person's estate. Let us look at the legal framework that governs revocation. The law provides safeguards under Section 263 and Section 383 of the Indian Succession Act. While both sections serve the common objective of preventing fraud and ensuring rightful representation, they apply to different types of grant. Where Section 263 governs the revocation of probate and letters of administration, which deals with the overall estate and inheritance, Section 383 governs the revocation of succession certificates, which especially deals with debts and securities of the deceased. Despite their differences, both sections outline similar grounds for revocation, including defective proceedings, fraud and concealment, false allegations, contradictory court orders. Additionally, 263 provides the situations where the revocation becomes necessary, such as if the will is forged, or a new will is discovered, or if the executus becomes unsound mind. To sum it up, revocation isn't just a legal formality, it's a safeguard against fraud and mismanagement, ensuring justice and protecting rightful heirs. With that, I conclude my introduction. To take this section further, I now invite Advocate Shrikant Kanetkar sir to share his insights. Thank you.
The word estate has been not exactly defined, but you can get from Blacklaw's dictionary. We have been told in so many times that if you do not get any, because when every act there is a section 3, either 2 or 3, which we all always call interpretation section, that is a definition section. Nowadays there is a fashion even in development agreement or joint venture agreement like this definition clauses. From where they get it, I don't know in that case, but all right, they do it. What estate contemplates according to me is all that person or any entity owes, including real estate, what we call immovable property, and personal property also. So this is the concept, or in short we can define and say the property that one leaves after the death the collective assets and liabilities of a dead person. My friends, I am told, I am subject to correction, that act has called Estate Duty Act. Why it was called Estate Duty Act? Generally, after a person dies, and a person who gets the property, maybe by inheritance or any other means, even required to particular pay the tax, a duty. Therefore, word use is not property tax. Word use was estate duty. It's a duty. It's a duty of the person. My friends, therefore, you will understand the meaning of it, the very intention and the particular issue was, you must know the very concept of estate and how it is administration. So why these provisions came? When a person is holding the property in his lifetime, he doesn't require anybody's assistance unless he has become old or something. He manages the property, administers his own property. Question arises when the person goes in the birds of aura, he goes up. Then in that particular case, question arises how to administer the property. If the proper procedure is followed or provision is made, which we are discussing since morning, will among so and so and so and so and so, so and so. Then in that particular case, who does it? Who find that well? Okay, if there is no dispute, we have already seen it, even will, if there is no dispute about it, persons can come together, there can be a settlement deed, can be a partition suit, maybe consider that well division between them, all other things. But even if in spite of the fact that there is a document of a will, apparently may be valid, still dispute, still somebody has to manage. Who has to manage? A third person. In a case of a will, a particular stranger may be appointed, that is a particular executor, or no executor, letters of administration, as we already discussed. That is not my topic, everybody has taken so vastly in that case, earlier both the speakers. So in that case, court manages it. Therefore, I, at the initial stage, congratulate Nilima Bhadbade, my sister, seeking such subject and giving the proper name to the subject title. What is meant by revocation proceeding? Title given is revocation proceeding. In the words of my senior friend, in the last stage, Vanaprasthashram, what we call it. A revocation is like Vanaprasthashram. Last, everything has been done, good, bad, and now whatever mistakes have been committed, that has to be cleared by the court. That is the revocation. Now, when we talk of a revocation proceeding, from the discussion from the morning, we can see that well, most of the things are related to the will. Forget about the succession certificate part of it or that heirship certificate. Basically, as regards managed by the court, because heirship certificate, whether managed, etc., it's not the concept so far as that certificate is concerned. Succession certificate is also not, according to me, correctly that well, courts administers it. I will try to explain it, but then we'll talk about the revocation. That book. I don't want to encroach upon the subject in the morning, what is that, but what is I want to, so that if you understand this, you will be able to understand the concept of a revocation, which is the other side of the coin. According to me, that well, major portion of revocation will apply to the probate, that is letters of administration, and to some extent succession certificate. No doubt there is a provision for heirship certificate cancellation also. So therefore it presupposes, contemplates that there must be a will. When we talk about revocation of a probate, revocation of a letters of administration or etc., in case of the particular succession certificate, there is never a will. And if will is there, there is a bar of 370, you can't apply for succession certificate, which is already considered by all the earlier speakers. Question is in that case, sir, that well, my friends, so revocation proceeding will govern so far as this aspect concerned. Then the further question is, what is mean by exactly revocation? You must have heard the word revocation. Power of attorney is revoke. If the power of attorney is revoke, sometimes a synonymous word rescinding, you must have seen in section 27 of the Specific Relief Act, contract is rescinded. So contract also, agreement that sometimes we say terminated, it can be stated as a rescinded, revoke also. So it has concept that, well, right is given to that effect, what I want to compare to the concerned party. For example, person who executes the power of attorney called as a principal, if there is some fraud committed by the agent, he says, I am revoking the power of attorney. Power is given to that particular person who executes in that particular case and that particular cases. Similarly, case of a contract, etc., etc. But like a compare along with this, if sale deed is executed contract. Agreement to sell is in that particular what we say that executory contract agreement. If one day if another person says, vendor says, I have executed sale deed, I revoke it. Can you do it? No, you can't do it. Property has already been passed. Already property has already been transferred. So concept of a revocation by whom and to what extent? Which according to me that concept to be seen is by whom and in that purpose. Therefore I told this and etc. etc. According to me, revocation means a very simple meaning, either recall or annul, maybe akin to it, cancellation or etc. And what is revocation? That means recalling or cancelling some power given already, or some deed executed already, or some power granted, etc., previously, generally by the court, and is something as contemplated by the law, something fraudulent, contrary to the procedure, etc., etc., right is given to the court. It is only court which will revoke that particular. Nobody other can say there is dispute. No. Though court, when I will point out which court, their power is as well. But take example, before a particular person is alive who has executed a will. This was not discussed, therefore I am saying, he has also got a power to revoke the will. He has got power to revoke his will, which may be one of the consent while cancellation of it if that document is suppressed. See, if I execute a will, I have got some dispute. Don't think that dispute with my sons or etc. And if I say no, if you are not doing like which I want to do, I will revoke the will. I myself have a right to revoke it. But once I am not in this earth, and suppose the application is made, and that particular time probate, take example, I have executed a second will after revocation, that last will what we call it. If that is suppressed and probate is taken on the first will, it's a fraud. Try to understand the areas. I am only putting out the points while considering the revocation, etc., etc. Though there is a specific section to that debate. Not today I am bound that only 263 is to be seen. No doubt 263, because the earlier girl who gave narration, she tried to put a particular net. Today's topic is 263. That means I am not bound by that 263 only. I will go also beyond that also with her permission in that full case. My friend therefore in that full case says that well, so previously granted by the court or any authority, that may be there in that full case. I just want to highlight the points in that full case. Now therefore we will directly go to the revocation of a probate or later subordinate, because together, though discussed in the morning, again I consider when we say revocation of probate, my senior learned friend Mr. Patwardhan both explained. But what is meant by probate according to me? In short, to admit the will of its proof. Or, as per today's subject, to administer the descendants' estate is a probate granted by the court. To administer what by probate, what the court does, it is absolutely directions given by the court. So first validate the will and then go to the particular administration, how it is to be transferred, etc. Very nicely explained in the morning lecture by our senior friend. So therefore, probate in that case, therefore say, administer the descendants' will, etc. Then if you want to go for a revocation of a probate or a letters of administration, before we consider what is the requirement of a probate? When the ground is there that it is contrary to the constitutional procedure which has been mentioned in 263, therefore we have to find out the procedure. My friends, as we always do, open section 276 and 278. According to me, grounds are embodied in 276, 278. That is why we have to read first that, then go to the 263. Petition for probate. What should be the contents? Just like when I always say, even as on today, suit is to be drafted. Maybe I have taught hundreds of times, I again go to the Order 7. Order 7, Rule 1. What should be the contents of the plaint? That gives me so many aspects. When you argue Order 7, Rule 11, you get a clause number E. Facts constituting cause of action, and when it arose. Whole case. Facts constituting cause of action, that is the right to sue. How you have got right to sue. And when it arose, that is the limitation. Both the most important points. So you write in the plain, cause of action so and so arose, so and so arose. That is a particular incident, may be made up also, to bring it limitation. What is important is facts constituting action, that is what is your right to sue. That what is your right to sue, that is to be point. Therefore now let us read it that well. Application for probate for letters of the administration with the will annexed. Our brother has already explained it, will annexed. Shall be made by the petition distinctly written in English, in the language in ordinary use in proceedings before the court in which the application is made, with a will or in a case mentioned in the section 237, 238, 239. Earlier, if somebody asked the question, if the original will is lost, answer is in 237, 238 and 239. Open 237, 239, read it cursorily. Even probate petition can be filed. 237, 238, 239. That is why I say always read the law, drafting. What this 237 says, probate of copy of a draft of a lost will. The one who asks the question gets the answer. Will is lost. Suppose you are drafting, case comes to you for probate. If you are not aware of this, what you are going to do it? So you will have to mention. And preparation for secondary evidence, therefore you have to put certain that, well, I have got the certified copy or copy, true copy, so many things are there. So even probate application can be made even the will is lost. No difficulty in that particular case. Or when will has been lost or mislaid since testator date has been destroyed by a wrong or accident, even it is destroyed, you have to make out a case, you are making a footing for secondary evidence. 238, probate of contents of a lost or a destroyed will. When a will has been lost or destroyed and no copy has been made nor the draft preserved, probate may be granted of its contents if they can be established by evidence. My friends, what else is required? Only thing is we have to open the law. That's all. Answer is everywhere in that case. Here I am not to say, but see Civil Procedure Code of 1908, which Britishers have drafted it. Even till today, for every particular query, every particular objection, there is an answer. Execution and therefore goes on 10 years, 15 years. Order 21, Rule 103. Every day for give an application for your execution petition will never come for hearing. But don't misuse the law. Otherwise, tomorrow you will go and say, sir has told us, read Order 21, Rule 23 and prolong as you like. That is not my argument, my friends. 239. Probate of a copy where original exists. Copy exists. When the will is in the possession of the person residing out of the state in which application for probate is made, who has refused or neglected to deliver up, but a copy has been transmitted to the executor, and it is necessary for the interest of the state that the probate should be granted without waiting for arrival of original probate, may be granted of the copy so transmitted. I want to make 2 points. Either you may be on behalf of the petitioner probate, that is for getting the probate, or a petitioner for revocation of the probate. You will have an answer. Sir, somebody comes in that case who can take a minute. Sir, the probate has been granted without there being any will, without action, say that way. I said, yes, oh, granted. Then they say, revoke it, sir, because it is false. I say, go to 239, go to 237, 238. That is why I stated, grounds are given in your legal provision itself. But if you do not follow the parameters of 237, 238, 239, and thereafter in that other aspect, certain provisions of Evidence Act, then, but I feel in that case is there. Now let us come again, 276. Now, what are these should be the contents, and particularly 276.3. What is the requirement? That is regarding the jurisdiction. Jurisdiction is of two types, territorial jurisdiction and inherent jurisdiction. See, what is that 276 says? And particularly subsection 3. Petition upon by the contents. Time of testator not much important, that the writing annex is last will and testament, that it is duly executed, the amount of assets which are likely to come in addition to the particular, the section further state when the application district judge that deceased at the time of his death, mark that 2A. Fixed place of abode or had some property situated within the jurisdiction of the judge. If you don't mention it and alternative happens, and both the commits mistake, lawyer, judge, Dhoni, and probate is granted. What is the fundamental requirement? Who can, which court can grant? That is related to the jurisdiction. As compared to our section 20 of the Civil Procedure Code, territorial jurisdiction, where the suit is to be filed. From 16, 18, 20, 16, 8, 16 says where the property is situated. Nothing new. Section 20 where the cause of action arose or where the defendant resides. But here exactly where the deceased decides. If you commit mistake and satisfy the court grants it, later on your certificate probate is bound to be revoked. See, it is inbuilt, section 276 is inbuilt. What further says that, well, 3, when the application is to the district judge, that deceased at the time of death had a fixed place of abode within the jurisdiction of such delegate. Now, my friend, therefore, again, they have provided, if you commit mistake in drafting or putting up your case, in case of a probate, if you commit this particular mistake in drafting and proving, because what is pleaded is to be proved. If no pleading, no proof would arise. Then in that particular case, therefore, and 3, where the application to the district judge and any portion of the assets likely to come to petitioner's hand. If you are pleading and no evidence beyond this, your probate is bound to be revoked. Bound to be revoked. So we are the killer of our ourselves. You are bad drafting. Your particular not giving evidence proper, that will entail. Just like we said that that seeds of Second World War were sowed in First War. That was always said. That was the cause of action. First war itself was the cause of action for the Second War. My friends, therefore, like this. Now let us go to the second 265. And 264. Let us see 264. Who has got the jurisdiction to grant a probate? See, 276 to be read with 264 and 265. What it says? 264, both for probate and letters of admission. 264.2 is most important. Read it. Except in cases to which Section 57 applies, no court, we call in our language non-obstinate clause. No court on this earth, no court in any local area beyond the limits of towns, Calcutta, Madras and Bombay, which my friend Mr. Patwalan referred all this exhaustively in that case. Since shall, where the deceased, a Hindu, Mohammedan, Buddhist, Sikh, Jain, ex-person, applications for probate or letters of admission, until the state government has by notification of official guidance authorized to do so. So what is the exception? No court shall, that means if the property 276 to A, B and 3, property beyond. I remember a case, not earlier we were discussing in Madras. I remember a case, I was appearing on behalf of in that case opposite. Petition was filed where that particular person ultimately died at Nashik. Entire property at Pune, his place of abode, but as become old, therefore he has gone to her daughter. So petition ought to have been filed here, in Pune, property here, everything that way. Petition came to be filed at Nashik. Client requested me, sir, you come there. I will come. I pointed out, still the probate was granted. Later on we say that now in that particular case, it was matter. I will not go into that matter, you go and find out. Appeal lies. I filed an appeal also. But matter was not stretched further. Ultimately compromise took place. As Horace earlier stated, that compromise took place, nothing in that case recorded, etc., etc. If that would not have been, what would have been the position? I was required to file application under section 263 for revocation. Now why I am inviting, what section 57 is made? Why reference of 57 is made? 57 says, particularly 1 and 2 says, certain cities, these three cities, as rightly pointed out Patwalan, what we would say, this provincial त्याच्यामध्ये, probate is must, mandatory, and therefore 211, 213, all sections come, no right. But if the will, property, everything as Pune, I need not take. He rightly stated in the morning that it is advisable to take a probate. But it's not mandatory on me. It's not mandatory for me because will, testator died in Pune, property in Pune, residence in Pune, I need not take it. But take example. If your client is residing at Bombay, that client has particular this property at Bombay, everything residential could happen. But he came just in Pune for some other reason, ultimately died in the hospital. These are the questions in the practice, not this particular theoretical, where you will file petition for probate. Will is there, executor is appointed. Make it, sir, I don't want answer. This is not a classroom, my friends. Find out an answer. Such critical aspects. Then, my friends, most important, and I was on the point, 265. Power of to appoint delegated district judge to deal with non-contentious cause. Again, that provides you a ground for revocation. How? Let us read it. The High Court, these powers are given to the High Court only. The High Court may appoint such judicial officer. Wording uses judicial officer. I will pause here for a moment. Immediately, upper section 264. Jurisdiction of a district judge in granting and revoking, both stated, probates, etc. The district judge, word uses district judge, not district court. What is the difference? Persona designata. I was conducting my friends on election petition, not boasting myself, of cantonment. A rule 7 of that contemplate election petition to be presented before the district judge. Particular person, not to make a criticize a lawyer, file a particular petition before the registrar of the district court. My client was served. We went there, and firstly I say, sir, dismiss the petition. Court was little bit, Mr. Kanetkar, you are a senior lawyer. On the first day you said, I read my application. I said, petition itself is not presented properly. It ought to have been presented. So, district court, wording kya hai? Rule 7, district judge. It has been assigned to you, additional district judge. Whether you are mentioning this. It is a concept of a persona designata. He said, Mr. Kanetkar, what is this concept? Persona designata. We were required to explain. Friends, therefore, in that full case, we pointed out that person who is named, who alone has a right to get it presented. According to me, that will, now other sections are there which are not much of there, but I am pointing out. But we have to see the difference between 264 and 265. The High Court may appoint such judicial officer, wording is judicial officer, within the district as it thinks fit, to act for a district judge as a delegate, to grant a probate and letters of administration in non-contentious cases. So, if there are disputable cases, etc., no. And wording is that will appoint for grant of probate, not for revocation. Who has got jurisdiction? 264, grant as well as revocation. Here wording says for grant of probate, not for revocation. So, this provides to you. Suppose take an example. Contentious matter has been through oversight what is made delegated. District regulated that he considers grants a probate. Nobody knows what is the defect, etc. If a lawyer like Patwardhan comes and he knows that well, reading by word, say that well, sir, this has to be particular case because it was a non-contentious matter, no, not contentious matter, it is a contentious matter. Probate has been how it is granted. It gives you a correct because if you see 263 clause, very procedure and it itself was wrong in that particular case. So this is what the particular position. Then 264 and 265 to be read with 288. Let us read 288. And then 388. Procedure where there is a contention, that means contentious particular proceeding, or a district delegate thinks probate because he has got power only in non-contentious matter. In every case in which there is a contention or a district delegate is of the opinion that probate or reference should be refused in his court or the petition with any document which has been filed forthwith shall be returned to the person by whom application made, order the same to be presented before the district judge. Go under section 264. Suppose it is stamp granted. Again a ground for particular revocation in that case. This is a principle like our order 7 rule 10 CPC. If the court has no jurisdiction, we have to point out you have no jurisdiction. He can't reject it. He can't refuse. He would say that, well, I am returning the plane. The same idea here. That is what. This is what my point is that well. Now read, my friends, 288, 388. Institute of an inferior courts. Now come. Read with 264. 264 uses the word district judge. 265 district delegate. 388 inferior court. Means what? Maybe municip, what we call civil judge junior division, civil judge senior division. He can also grant a probate. But what are the circumstances? If that procedure has not been followed, immediately 263 revocation. What is that? The state government may by notification in the official gazette invest any court inferior in grade to the district judge with the power to exercise the function of the district judge. And if you read entire section, they say as if he is a district judge. But if this procedure is not followed, because when we say ground under 263, very procedure, whether in the aspect which is faulty, that will be a ground for revocation. So therefore, now my friends, here even a civil judge junior division can grant it, provided powers are delegated to him. Because he is not acting then civil judge junior division, he would be acting as a district judge. There is the argument of persona designated, will everything go. My friend, therefore, these are the aspects. Therefore, I thought it fit, before we consider what are the grounds for challenge, which is the only section my colleague told that, well, sir, we have to point at 263. Why you are traveling? I tried to travel because of reasons, you know that. Provision for revocation 263. Only see the grounds, my friends. I will not tell in much. I want to tell certain substance to you that well, and I will ultimately give certain list of authorities which will help you that in that case. In which I also rely upon Birla versus Lodha. It's a landmark judgment in that case. It's also on point of revocation in that case. (263) Revocation and annulment for just cause. Therefore, I use the word. Revocation means what? Revoke, take back, and also annul. That is what the word used by the legislature. The grant of probate or letters of administration may be revoked or annulled for just cause. According to me, the last word you mark it, just cause. It doesn't define, but certain illustrations are given which we can say are the just cause. It is not like ejus dim generis, what Solomon says. Where in case the husband says to the wife, go and bring some vegetables and fruits. Wife go and she says, anything. She goes and purchase gold bangles, come back, pocket is khali, husband ka. Will it be proper if wife always? No. Ejus dim generis does not mean like vegetables, fruit or some grocery, not gold bangles. That is what exactly we have to understand the concept. So concept is a just cause. Main, it governs the other grounds. Let us read rapidly and directly go to the aspect. The proceeding to obtain a grant were defective. Therefore, I read this. The first ground. Now you will understand why I pointed out 263, 264, 265. And then I came to 63, 237, 238, 39, 276, clause 2, 3. These are the reasons. The first ground itself. The proceeding to obtain the grant were defective or substance, or the grant was obtained fraudulently by making a false suggestion or by cancelling from the court something material to it. For example, reference was made, and if I remember the facts, I use that particular judgment, Birla Lodha. Some document was suppressed, that is what the settlement deed, etc., etc., or some and proper, no, sorry, husband and wife, a joint will. Then in that particular case, the husband died before the wife. Wife executed a second will in that will, and probate was obtained on first will. That was a fraud. We have to understand this. I will tell you when I will judgment Lodha, I will give citation to you, my friends. These are the particular judgments in my diary always. Yes. Grant was obtained fraudulently, making a false suggestion वगैरे वगैरे आपण बघितलं. C. The grant was obtained by means of untrue allegation or essential facts. The grant becomes useless and inoperative. The person to whom. My friends, there is no time to explain each and every ground, but I will tell you substance. Let us go to my file illustrations. You may have come across Evidence Act, Transfer of Property Act, Contract Act. Always there are illustrations. What is mean by illustration? I will give you citation. Supreme Court has interpreted illustration nothing but is a part of the statute itself. So these are the grounds. Illustrations, what it says. First illustration. The code by which grant was made had no jurisdiction. I just now pointed out. Ready reference. 2. Illustration 2. The grant was made without citing the parties. Our senior friend has exhaustively taken to us. What is mean by citation? CITATION. It's a writ or order of the court, serving the summons to the other side. If having a cavitable interest or otherwise, the summons is to be served. In language of the Bombay High Court lawyers, they use always the big words. We are official lawyers, we don't know this. Writ. While defining the citation, they use the word writ. So therefore, writ in short means nothing but that summons. So if I will point out one judgment, even there was no other provision because the legal heirs were not brought on the record. High Court or Supreme Court has stated it is the bounden duty of the municip to issue it. Considering earlier section 41 or read section 35, effect is because who are covered when he said right to remain extensively in that case, not only person where the dispute is going on in any other court where will is involved, where I just now pointed out, know that well. After this could not succeed, therefore he filed a suit. What has happened? A Christian lady who was looked after only her niece, property at Pune, and she particularly executed a will in her favor. When this niece was at Bombay, sometimes the jockey, how he has contacted residing in the same society, got sanctioned, etc., and got a will executed. I am not boasting, I exactly cross it. Because his argument was, my will is last will, section 70. Judge also said, Mr. Kanetkar, yes, let me take cross. I know. I am aware 70, I am aware everything, last will, everything. And I took it from his horse's mouth. In cross, everything. And one more aspect, which just now Patwardhan person, 154B 113. That was a property in housing. There were different concept of a title. I pointed out, you say a will transfer to you that flat. Where is the provision transfer a flat in a cooperative housing society? And their contention was, it was agreed to be transferred. She forged some fake document and say, but that could not happen. Therefore, she executed a second will. That is the last will. Now, we are not, I am going on the point of title, even in all these cases, question of title cannot be decided. But I pointed out just to show how that will is fraudulent. That is the concept. The will which was probate was obtained by force revoke or revoke. I am going to point out one judgment, which so many times it comes. What has happened in that particular case, I think that must be a Lodan, etc. That was not. Will was, I told that well, a person can revoke the will in his lifetime. That was suppressed, and on second will, probate was obtained. Will probate gone. This is what the position. 4. Obtained letters of administration, etc., but it is since transpired that she was never married to him. I take a case. A has administration of B if in test based on 7. Friends, when we get point time, we can discuss this everything, but now you have got the point. These are the specific grounds. If you read the entire these particular sections about jurisdiction or etc. validity, you will get the ground how etc. etc. Since probate was granted, codicil etc. we are not person to whom. Now let me friends point out so that which I pointed out earlier. We are trying to complete it within period of 5 minutes so that There was one case where you can take it down. Otherwise, I will give citation with the Varsha madam in that case. Year 2009 NOC, Calcutta, page 3005, a division bench judgment. Mazli versus Mazli. What has happened was obtained on the basis of a probate, that compromise deed. Case was that revocation, that you compromise only typed in everything. Court has not recorded, you are not satisfied that there were our signatures. You have not recorded the satisfaction. You say compromise, probate granted. Therefore, the person who was disputing that compromise deed gets a caveated interest, which our friend has explained. This is meant by caveated interest. He gets a right. You have compromised deed. Our signatures are not there. We have not seen it, etc. He says his own signature and you accepted it. That is the meaning of it. Exactly in that case. There is one more judgment, AR 2008 Supreme Court, page 295. There was no citation in that case. Made to a concerned person or instituent person, he was right to object to grant a probate. So, right to be in that case, again, caveated interest. That was again Supreme Court judgment. It was the revocation was granted, probate was set aside. Section 3F refers who are the heirs, Succession Act. And to mean any person, male, etc. So, who were required to be again cited, served, etc. that aspect. Supreme Court upon matters, also they say that where the citation is not proper, it has to be. You will find major grounds, my friend, on citation and fraudulent wills, etc., etc. Or suppression of fact. Grant of probate taking judgment in rem. Person who is aggrieved thereby had no knowledge about the proceeding, that is revocation proceeding, citations were not made. He is entitled to file an application and probate is to be set aside. My friends, next is regarding caveatable interest, a specific judgment which our both the friends have referred. I will only give citation of Birla Loda, 2008, volume number 4, Supreme Court cases, page 300. All the sections have been considered and pointed out what is meant by caveatable interest in that case. Then revocation, section 290 and 295. This is judgment of our own High Court Division Bench, Khande Parker and F.B. Mazmudar. Hindu Succession Act 290-295. Letters of administration, revocation of appellant's daughter of deceased, claiming that letter of administration obtained by their grandmother in respect of the property bequeathed by their deceased father in her favor, and therefore that was why. Mother of the appellants had remarried in England after divorce with the deceased, and appellants were adopted by her second husband as per the prevailing in UK. Having claimed the right as adopted child in respect of their adopted father's property in UK, appellants are not entitled to succeed to their natural father's property in India on the ground that their adoption as per etc. Dismissal of the revocation petition, I am pointing out others, where there is a question of title was involved. Neither probate court nor succession court can go into the merits. On the contrary, if you see the provisions of section 370, 373, etc., succession certificate in respect of like a concept of a nominee. A landmark judgment came in 1986 by the Supreme Court on the nominee. The parties, you may be knowing that. Yes, Srushti Devi. What is the concept? Same concept of a succession certificate. nominee doesn't get any right. He is a trustee. Supreme Court laid down it. What is meant by trustee? That he has to protect the interest of all. So what right? He gets a right. This is for third righty person, other persons, as rightly pointed out, for others. If you go to the bank, say that will pay me us, bank will say no. LIC go, no. Bring a succession certificate. That is for the benefit of others, not for the respective parties. This is what the judgment based on that. Then my friends, 1955 Supreme Court, page 566, Bose versus so and so. No, sorry, not Bose, no, party. 3 judges judgment. Full bench, not full bench, larger judge. In Supreme Court, you use the word larger bench. Defective substance meaning. The word pointed at 163 ground A. Defective in substance meaning non-citation of next reversion to testator's estate, whether sufficient for revocation of a grant of probate? Yes. AR 2008 Supreme Court, page 295, about succession certificate. 263, probate, revocation. All places where properties of testator were situated, not disclosed in the application for grant of citation, could not therefore be published in all places, sufficient ground for revocation. See, we read 276, 278, what should be contents, etc. This is what the position is. You will get all the ground. Law is not far, my friends. It's not very difficult to understand. Read line by line, comma, paragraph, understand the subject, and then you will find it, my friends. Next, 2008, volume number 6, our judgment of Bombay High Court, 593, Jagdish Mehta versus Sumitanand. It is judgment of D.B. Bhosle. Order 22, Rule 4. Proceeding for caveat filed to oppose the grant of probate. Death of caveator. Procedure solemnly duty cast upon the probate court. Under 264, 265, that court is called as a probate court. If caveator and heirs of the plaintiff fails to bring them on the record, but should either by direct the plaintiff to bring them record, not done, revocation. Then letters of administration, one more judgment, my friends. 2024, volume number 5, a very latest judgment. Revocation, non-service of a citation. Most of the judgment I told you that will on this part are spread, which in the morning session our senior may very emphasize it in that full cases, and restoring the publication, etc., etc. 2019, latest judgment 5, SCC page 58 on succession certificate. A succession certificate can be granted in an application in which necessary particulars are set out as mentioned in 372. There is no dispute that the application made by the appellant and set out the aforesaid particulars. The certificate to granted cannot be revoked. I am giving judgment from both the sides in that process, unless and until subsection A to E of section 373 are satisfied. That is, grounds are satisfied. And the last judgment, and I close. It is under the Bombay Regulation That Act, heirship certificate. Provision 390. Provision with respect to the surface under the Bombay Regulation Act. Specific section, my friend. Sometimes lawyers come, they ask me, of course, good thing that ask it, sir, where it is to be filed. The very concept has been incorporated, the judgment by S.C. Gupta, a very renowned judge in that full case, a very learned judge. And he has referred the judgment 2018, volume number 1, March page 681. He says that when for seeking revocation of a certificate granted under Part 10 of the Succession Act or the heirship certificate so and so under 1827 Act, the applicant for revocation must make out 3 ingredients. Firstly, it needs to be shown that there is a false suggestion or concealment of a material particular in the application as to the heirship certificate. So many times we I have come across, wherein there are 2 wives. there, etc. And what happens, my friend? The fact is suppressed. Amount claimed by first wife, file certificate on the basis of heirship certificate, obtained succession certificate. Later on, a second wife came to me. Sir, काय करायचं? म्हटलं, let's see what happens. But only provision is 383. Because though heirship certificate, but that heirship certificate was fraudulent. Therefore, we have got power under 390, 200. My friends, I am thanks to the organizers. Though it is my institution, I must say that I have been given opportunity. After several days, I am feeling fresh, because when I give lecture, I give fresh. So therefore, my friends, this is what the subject I have tried to conclude it. Thank you, my friends.